Hey, it's Chad Brown. Welcome to the Disability Expert Podcast. I am so glad today to have Maria Vargas as my guest. Maria, thanks for coming on the show.
Thank you, Chad.
So let's just start with this issue. So clients come in, they've got their notice of hearing. It comes in, they see this person, the vocational expert or the vocational witness, and immediately they're like, who is this person? Why are they there? What are they doing? So tell us just a little bit about that. Like what is a vocational expert, and what's sort of your role in the Social Security disability hearing?
Sure. So in the Social Security realm, basically the judge is there to make a decision about your disability case. So they rely on, usually people have an attorney, they rely on the medical records, and you also have to fill out the work history forms. That's a really critical component of your disability determination. So judges have vocational experts that are hired by the Social Security Administration to be there as impartial fact witnesses. So we are not on your side or against you. We're not for the judge or against them. We are there just as a resource to provide information. So prior to the hearing, the vocational expert will have reviewed your work history so they understand what types of jobs you've done. And in the hearing, they are there as a resource to the judge. So there really is no interaction between the person who's coming in for the hearing and the vocational expert. The vocational expert pretty much sits there until the end of the hearing, and then the judge provides questions to the VE, as we usually call it. And if you're representing by an attorney, they can also ask questions of the VE. So we're really there as kind of an informational resource. We don't determine the hearing. We don't make any decisions. We just help the decision maker in whatever questions he may have about work and work capacity.
Okay. So one thing that happens, I know this has just been in thousands of hearings, they use this hypothetical format, which I think really sort of throws claimants off a little bit. Can you just talk just practically about how the judges ask questions in vocational to the vocational expert in the hearings? They use this hypothetical format. Can you help a claimant? Let's just say someone's listening, they're a claimant, and I know they get confused. They don't understand, because the person looks a lot like them, but maybe it's not exactly like them. Can you talk just a little bit about how judges use that hypothetical question format when they're questioning you as an expert?
Yes, and it is unusual. That's really the only type of court that I go to where you have a situation like this. But really what the judge does is throughout the hearing, as they listen to the medical evidence and they've studied the evidence, at the end of the hearing, they form a hypothetical. So hypothetical means kind of a what if. So what they do with the vocational expert is, having listened to everything throughout the hearing, they basically pull out what limitations they think are applicable to the case. So even though you may say you have a lot of different limitations, the judge may not accept all of those. So the judge accepts what he or she finds is supported by the medical records. So at the end of the hearing, the judge does a really fast hypothetical to the VE, and they say something like, Madam VE, would you consider an individual similar age and work background as the claimant with the following limitations? And then they give us a laundry list of limitations to consider. They may be mental, they may be physical, it may pertain to the environment. So we're given that. And then they ask, given these limitations, are there any jobs? So at that point, the vocational expert has to come up with jobs that fit all of those limitations and also fit the types of skills that the individual has. So when the VE is giving jobs, I know sometimes this has happened in court, I may be suggesting jobs that might fit that. Sometimes the plaintiff may say, I can't do that job. I've never done that job before.
Yeah, sure.
And I understand, because they really don't know what's going on. There really is no need to do that because the attorney understands what's going on. And if there's questions to be asked, they will ask those questions. Again, it's not the VE saying, you can go out and get this job. It's giving vocational and job information to the judge. And then the judge uses that to make a decision.
Yeah, and I think a lot of clients misunderstand that the judge may or may not find them to be like that hypothetical individual that's in the VE question. In fact, a lot of judges ask multiple hypotheticals. They'll ask 2 or 3 or 4. I mean, sometimes they ask 5 hypotheticals. They'll ask a ton of hypotheticals. And so I think it's important for clients to understand, yes, this hypothetical individual bears similarities to you. And, sometimes that hypothetical question produces no jobs, right? And so that would mean if that hypothetical individual looks like you, then you're going to win the case. I think it's important for clients to understand, this is just part of the process where the judge is trying to work through what would someone be able to do if they had ranges of limitations. And the vocational expert is the person who can come in and say, well, if the person could do this and not do that, then these are the types of jobs they would be able to do. Yeah, very good.
Right. It's just the questioning process, and it seems unusual because the person is sitting right there. And
Right.
sometimes they don't ask a hypothetical at all because they've already made a determination. So sometimes the VE really won't even have a role in the hearing after sitting through all of it.
So one of the things that I think is important for clients to understand, and in the hearing, I don't want to belabor this, but in the hearing, the claimant should never engage with the VE. Like they should, you hit on that earlier. They should never talk to the VE. It's not your place to do that. You have a lawyer. I mean, if you're not represented, you can ask them questions, but that's aside. So, but the vocational expert is a really important person in the hearing because you're giving testimony that could be the foundation for an approval or a denial. What are things that clients can do when they're working with their attorney or preparing their case to sort of frame the issues that you're going to engage with in a way that helps them win their case? So while they shouldn't be engaging with you directly, there are things they can do before the hearing to help prepare their case to have a better chance of winning. From a VE perspective, what kind of things do you think a client should be doing with their lawyer to help improve their chance of winning?
Well, I think at the very beginning, when you file an application, that's where it really starts. And the application with the work history forms and things like that, that is what the vocational expert reviews on the file. That's all we know about the file. So when we're going into a hearing, most people do a pretty bad job of completing those forms. I'm sure when you're filing your application, this is the last thing I want to do is fill out all this information. But that's really all the vocational expert has to go on. Sometimes during the hearing, your attorney will ask information about your work history, but not always. So complete the paperwork well. And, anymore, we really only have a 5-year look back for vocational background. So whatever your jobs were within the past 5 years, any information you can give about that would be really helpful. Don't remember exactly everything on the form, but the title of the job, if you don't know, try to figure it out. Sometimes people just say they don't really know their job title. But if you don't know that, maybe put the company name. So maybe it's, Jimmy's Textiles, Hickory, North Carolina, machine tender. That's because vocational experts will go look it up. We'll figure it out if you give us any kind of clue whatsoever. And then also on there, it asks you how long you were standing, how much weight you were lifting, things like that, because it's really, really important to know, did you have a light job? Did you have a really heavy job? That all factors into how the judge makes their decision. So one of the hardest things is usually people don't really know how much weight they lifted, which I totally understand. That's not a normal thing that people think about with their jobs. But if you can even describe in the work history, had to bring in bags of materials 5 times a day, that's very different than if you're sitting at a desk. So any kind of detail you can give will be very helpful, because if you don't give good information, the VE can't classify your job correctly. And if they don't classify your job correctly, that can have a major impact on whether the judge can award benefits or not.
Yeah, I think one of the things that we've seen over the years that we really focus on in my firm and other, I've talked to this topic came up. I can't remember which podcast it was. It came up with one of the other attorneys about how it's sometimes jobs are very clean. Like this is a machine operator job and we do specific things, but a lot of times jobs aren't clean. Like they're doing multiple types of jobs, or there's a blending of job, a composite job.
Right.
And I think it's really important. I think the key takeaway for claimants there with what you said is they need to get the detail correct. You can't have too much detail in the work history report, because the more detail we have, the more accurately we can report the job.
Right. And really, it's your job. You know your job better than anybody else.
Sure.
So you've got to take a little bit of time and realize you're telling somebody who has no clue what you're doing. That is really critical. And that's done up front. And if it's not done up front, you can still salvage it. You can update those forms later. They can be resubmitted. And your attorney could even bring that up in their presentation and say, the work history was incomplete. I would like to provide a better work history at the beginning of the hearing so that the VE that can then give good information. So you can always add that in, but it's important that you take a few minutes and think about, what was I really doing as far as how strenuous your job was.
Yeah, and this is something that comes up in the hearing too. While clients shouldn't be engaging with the VE, if there's testimony from the VE about their jobs in the hearing, and they're like, "Whoa, I didn't do that," or
Yeah.
"That's not even close," like that's when you need to slide. That's when you need to tug on your lawyer and say, "Let me send you a note because that's not what I said."
Right,
So,
exactly. We hope it doesn't get to that point, but if it does, if you hear something you're like, that doesn't sound right, let your
right.
lawyer know, let them address it.
Maria, thanks so much. Thanks for coming on the show. I appreciate it. Great seeing you again and talking about these super important issues. That's it for today's Disability Expert podcast. Please subscribe and be with us next week when we bring on one of the nation's best disability lawyers. Thanks a lot.